Yes, Ms. Cole.
My Lord, yesterday you asked whether...
Sorry, one moment. Yes.
Whether the observations of Mr Justice Bromby were in MM were overturned.
Yes, I did.
And Mr Allen has had a look at this, and we think that they were. The reference is, I won't ask you to turn it up, but it's at page 648 of the authorities bundle, at paragraph 97.
Sorry, I think we will turn it off.
Yes.
I think it's quite important.
648.
I mean, this is an important judgment for all sorts of reasons.
Yes.
It includes the famous passage at paragraph 120. All life is an experiment.
Yes.
Go to Oliver Wendell Holmes, which is cited a lot in my experience in
Yes.
judgments. So this is 644, isn't it? 644 is where the quote is. The bottom of in paragraph 81.
So, sorry.
Page 644,
Yep.
paragraph 81, the sideline passage.
Yes.
Is the last two sentences are the part which have been cited
Yes.
elsewhere. And my question to you was whether that bit is obiter.
And we think it is because capacity was simply not an issue in the case. Paragraph 97 on 648 under the heading Capacity the Facts. Official solicitor accepts Dr Milne's evidence, so do I. Dr Milne's evidence was clear and convincing. It stands unchallenged, even if MM and KM don't accept it. And in the light of that evidence, I find that MM has capacity to consent to sexual relations, lacks capacity to litigate, etc.
Is this a case? Was it obiter, or was it an issue on which the evidence was all one way and not challenged?
I think the latter. This was somebody had been a detained patient, had schizophrenia.
You mean the former, I think.
It was right. It was certainly unchallenged and
Yes.
all one way, and therefore there was no argument about the test.
Yeah.
I suppose then one could say it's moot as to whether counsel thought that the test did include a belief requirement, and or whether they didn't.
If it's an issue on which the evidence is all one way and therefore unchallenged, therefore on which there's no argument, I don't think, nor more precise than I am, I don't think it's technically obiter.
No, I think if something is something that needs to be determined in the case, then it is part of the ratio, even if there's no dispute about it. If it's a necessary part of the decision, then technically I think that constitutes part of the ratio. Obiter dicta are where a judge says something by the way, even though it's not necessary as a step in the reasoning to reaching the conclusion in that case.
But the fact that the question of capacity was an issue doesn't necessarily mean that what the judge, what Mr. Chestnut said in paragraph 81, is not obiter. Because, and I haven't looked at this, it probably would be obiter if his observations about belief were not relevant to the issue of capacity in that case.
To put it another way, if I may, if the judge can't be bound by concession.
Yes.
and we, as we know from yesterday's deliberations, the judge is not necessarily bound by expert evidence. So if the judge had thought, I think capacity is an issue in this case, because everyone's proceeding on the basis of the wrong legal test, it would have been open, I think, for the judge to say, I don't agree with Mr. Justice Thorpe, and that's not the test, certainly not the test under the 2005 Act. Mr. Justice Mumby didn't say any of that, so he appears to be approving, as a proposition of law, that the 2005 Act does require belief as an inherent part of understanding, using, and weighing. I think.
Thank you. There we are. I've also been asked, and it may be helpful, just to highlight what we generally feel we mean when we talk about weigh, the weigh function of the test. At paragraph 20 of the official solicitor's skeleton argument, page 285 of the core bundle.
Sorry, which page number?
285, paragraph 20.
Sorry, paragraph
20.
Thank you.
285. Paragraph
We're
20.
not getting off to a good start here.
No. We've all got a lot on our
Sort
minds.
of thing we're all.
I've just set out there the well-known formulation of what that function is, as explained by Mr. Justice Headley in PCT and PAH and others, that the capacity, the use and weigh functions, the capacity actually to engage in the decision-making process itself and to be able to see the various parts of the argument and to relate one to another. So I think that has been approved in a number of cases since and is an oft quoted and generally accepted explanation of what it is that the person whose capacity is under consideration is required by statute to be able to do in order to make a decision.
I think that's where Mr. Hemachandran may be able to help us if necessary, got his sort of coda from. And
Yes.
he said they've got to be able to see that the other side might be right.
Yes,
Do you think that's drawn from that?
possibly.
Hedging your bets.
Well, because I think all that you need to be able to do is understand the relevant information.
Yes, yes.
You don't have to be able to see that the other side
Well,
has to be
that's why I keep going back to that in a rather sort of annoying way, like someone picking at a ragnail. But I was concerned about understanding why that coda had been attached.
It seems to me that what Mr. Rockheim was there saying is almost like an explanation of the word understand. And I think, for my part, take the view that we don't need an explanation of that, whereas use and weigh is perhaps something that is helped by a formulation of what is that getting at in terms of the function that is required, whereas to understand requires no gloss, explanation, or further development of that function.
If somebody gives zero weight to something, I think you would submit that that is still giving weight, that they are, if one is asking, are they able to weigh? Yes, they are. It's just the fact that they give zero weight to something doesn't mean that they're not able to weigh.
Yes.
And it may not be helpful, but in different areas of the law, often the same concepts pop up. And it's well established in planning law that matters of weight to relevant planning considerations are for the planning authority,
Yes.
not for the court. And that they can give a relevant planning consideration 0 weight. They haven't erred in law. If they thought about it, they do weigh it up and they say we're giving it 0 weight. So I stress the analogy may not be helpful, but insofar as it is, I think you would submit that the mere fact that the patient doesn't accept what the doctors say and therefore gives what they say 0 weight doesn't mean that they are not able to understand, use and weigh it.
Yes.
It's just that that's the conclusion that she's come to.
Yes. Judges have to obviously weigh when they're exercising a discretion all the time, and I wondered yesterday if we're thinking about this in too legalistic a way, but sometimes when people are making the difficult argument of an appeal against the exercise of a discretion, they say, well, the judge wrongly failed to take something into account, or the judge disregarded something, and the response is, the judge did take it into account. The judge did have regard to it. He simply attached no weight to it, and therefore it wasn't a matter that he brought to bear when reaching the decision that he did. But he didn't ignore it, as people often say. And it's the same sort of thing, I think, for somebody making a decision. I'm not ignoring what you're telling me because I've got my fingers in my ears and I'm not going to listen to you because I don't like what you're saying or I disagree with it. I've heard what you said, I've understood what you said, I've thought about it, and I'm going to make a decision in the opposite direction. I fundamentally disagree. And that may be for rational reasons, or it may be for irrational reasons, and then one looks at that in the context of impairment and so on. I'm going to...
If I just ask you,
Yes.
have you made submissions, or are you going to make submissions on what Mr. McDonald said in the King's College case?
On impairment and diagnosis.
On weighing.
On weighing. I wasn't...
Well, it might be helpful to look at this.
Yes.
I know we're coming down to some sort of trouble with it, and I have a feeling that we've done it wrong. Paragraph 38 of what Mr. McDonald's judgment in the King's College case, page 429. And the word he, one of the points he makes is underlined. The word unable in section 3.
So what paragraph are you in?
Paragraph
This
30.
is the King's College case, tab 24, page 429, paragraph 38. Somebody's sidelined it, I wasn't sure. Yes, I think it's Mr. Sachdeva, I think, who's referring to this.
Yes.
And he, it's unable is the word that stands out to my mind in that analysis. And that is the word in paragraph 31.
Yeah.
So it's an inability.
Yes.
And as I read, I'm grateful to my Lord, because as I read that passage, that's really making the point that I was putting to you, that even if you give something no weight, it doesn't follow that you're not able to weigh up.
Yes. So where he says will not be satisfied, what he's saying is the inability bit won't be satisfied because the person is able. Yes. And then he goes on to say, within this context, a person cannot be considered to be unable to use and weigh simply on the basis that he or she has applied his or her own values or outlook to that information. Which could be said to be pertinent to this particular case.
I don't think that passage has been considered by this court before.
I think that's right. Because we
Sorry,
have...
There haven't been protection cases dealing with that point since 2016.
Yes. Before we leave it, and just thinking ahead to submissions I'll make in a moment about impairment and evidential sufficiency, it might be worth looking at the beginning of paragraph 39. Whilst the evidence of psychiatrists is likely to be determinative of the issue of whether there's an impairment, the decision as to capacity is a judgment for the court to make. And then he goes on to quote the passage that we put in our skeleton argument of my Lord's decision. The word likely may be of interest. Lord, just very briefly, to go back to what you referred to as the archaeology yesterday. I won't make too much of this, but as you'll have seen from paragraph 7 of the official solicitor's skeleton argument on page 281, it does seem, oddly, that what Lady Justice Butler just said was an observation made by Mr. Justice Thorpe in Re-C. Just wasn't. I keep rereading the judgment to wonder whether it's there, and I just missed it the first 3 or 4 times I read it trying to find its absence, but it isn't there, and we haven't been able to find it anywhere else and don't know where it came from. In some ways, it doesn't matter because it doesn't bear directly on...
Pre the act.
It's all pre the act.
All your archaeological discoveries before...
They're all pre.
Before the act.
But this bit is continuously sort of repeated and has become discussing with Mr. Keane yesterday, almost become an urban myth, because when you look into it, it isn't there.
Well,
and the part of
more than one citation of what Mr. Justice Thorpe said in BC is in reported speech rather than a direct quote.
Yes.
And it's different, and so that means somebody's edited it.
Yes.
In some way.
Yes.
Somebody's like, oh,
Yes.
So we don't know, we're no further forward knowing where...
We're no further
they just
forward.
Stop that.
No, it must have come from somewhere, but quite where and what it was about exactly, we don't know. Before leaving the issue of belief, I just want to touch on one of the mischiefs that we think there might be if there is a belief requirement to any part of the functional test, whether all of the general requirements or any one of them. And I've dealt with this in writing on page 289 under the heading An Anterior Misstep. If there is a belief requirement, then the danger might be that you start with, does the person believe what I'm telling them? Do they believe the relevant information? Because the thinking might be, well, if they don't believe the relevant information, then they don't even get off the ground in being able to meet the functional test, because it's underpinning every single part of it. And therefore, one steps away from JB, and step 1 is, do you believe it? And then, well, we don't even need to look at whether you understand it, can use and weigh the relevant information and so on, because you don't believe it. So that knocks all of that out. And then we move straight from your disbelief in the relevant information onto impairment. And that sort of collapses the two parts of the test into one, or conflates them. And that's what I was getting at in paragraph 40, that if that approach is taken, then it's a fairly short step from, well, you don't believe the information I'm giving you, and I see that you've got an impairment, and that way you must lack capacity. It becomes almost circular. You don't believe it, you have an impairment of the mind, ergo you lack capacity. And many more people are found to lack capacity than would otherwise be the case. Moving on to impairment. I think we're largely, I think, talking here about evidential sufficiency. And I wanted to go back to an argument that I think my learned friend Mr. Quintavalli was making about JB. As I understand his argument and what he was saying about evidential sufficiency in relation to impairment and JB, he was not, I think, suggesting that you should say that the Supreme Court has incorrectly decided the steps and the order of the steps that must be taken. And this perhaps goes back to my Lord's, does it matter in which order you do these things? But what I think he was saying is that where the court is deciding whether somebody does or doesn't have capacity, and this goes back to my Lord's point yesterday about re-T and what business has the state in even thinking about my capacity. I think what he was saying, and he'll correct me later if I've got this wrong, is that there must be some evidence that underpins all parts of the statutory test before the court is allowed to embark on deciding whether or not somebody has capacity. And the reason that some evidence in relation to all parts is required is because of the statutory presumption. So there has to be something that enables all parts of the rebuttal to be made good. And I think what he was saying is that, and I wasn't at the hearing, don't know whether the point was taken before Mrs. Justice Roberts, in circumstances where the two independent experts are both saying there is no impairment, and I could be right or wrong about this, nobody else had made an assessment of whether there was an impairment. It wasn't open to the judge to embark on the process of deciding whether Zidiksha did or didn't have capacity. That may not be his submission, I don't know, but I think that might have been the point that he was trying to make. As I read the evidence, Dr. Tunnicliffe had done an assessment of the functional part of the test, but hadn't made an assessment of whether impairment was present, and then only gave his opinion about it when asked questions in cross-examination, or perhaps in chief as well. That's difficult in circumstances where there was evidence of a situation that could perhaps be said to amount to an impairment, and the decision maker in relation to whether there is impairment being the judge rather than an expert. And perhaps one of the things for this court to think about is the circumstances in which it may be open to a judge to be the decision maker as to the presence or absence of impairment in circumstances where experts are saying there is no impairment and nobody else has provided evidence that they believe an impairment to be present.
Can I just ask you, it could be that you're saying one or both of two things. I'd just like to tease that out if I may. It could be a strong proposition of law, that in those circumstances it's not open to a judge as a matter of law to conclude that there is an impairment. Or it could be a slightly weaker proposition, which would be that it's not reasonably open on the evidence. So it's not a matter of law in all cases, but that it's not reasonably open, given that's the state of the evidence. It's not reasonably open to the judge as a matter of evidence to reach that conclusion. Do you invite the court to take one of those positions, or do you advance both in the alternative? Or?
We invite the court to definitively not take the first course and say that as a matter of law it's not open to the judge.
That's helpful.
We invite the court to say that it can be open to the judge to be the identifier of impairment and the finder of the presence of impairment as a fact. Caution will be necessary in circumstances where experts have said there is no impairment. And we thought carefully about this overnight, and I'm indebted to the helpful discussions that I've had in particular with my instructing solicitors, Anna O'Connell and David Edwards, both of whom will be well known to this court and sitting behind me, for their thoughts about this overnight. Practically, there could be occasions where a case comes before a judge, perhaps out of hours, on an emergency basis, and there is no evidence about impairment, but there is evidence about a situation. For example, somebody appears to have been found incapable, perhaps through drugs or alcohol or something like that, or perhaps somebody is found wandering around on a very cold night, insufficiently clothed, unable to tell you who they are or where they live. There would be but no chance to perform an impairment assessment, and perhaps no medical or information available about the individual. In those circumstances, there might be evidence that a judge could rely on, even in the absence of any medical information at all about impairment, for example. But we struggle to think of very many circumstances where a judge would be finding impairment without some direct evidence bearing upon it.
Well, can I just go back effectively, tying that in with ground one?
Yes.
Because is what you're saying really very different from saying that a judge decides, an expert advises? If a judge disagrees with experts, the judge must do so on the basis that they have material to do so, and they give adequate reasons for doing so. I mean, is that not actually what you're saying?
Yes,
The material, you're saying the material is likely to be medical evidence,
yes,
supporting the contrary view, and as Mr. Justice MacDonald says, it's likely to be that it will be decided by the experts, or determined ultimately by the experts. But actually, are we not really looking at the application of first principles, as they effectively are now, in a rather difficult and unusual situation?
yes. I think that's right. The only point, and it's in a sense not my argument to make, because I'm not concerned necessarily with the rightness or wrongness, is the material and the sufficiency of material in
Well, that's
the absence.
always the case, isn't it, Ms. Scott? I mean, any appeal can be run on the basis of this is what the experts said. They're very experts. There was nothing else to contradict their evidence, or there was some faint subpar evidence. The material was not sufficient, and that can ground an application to appeal.
Yes. I think.
Sorry, am I being
I
slow?
don't. No, not at all. I don't disagree at all. I think what Mr. Quintavalle is getting at is.
I know what Mr. Quintavalle is saying. Mr. Quintavale's case is no, you can't. unless you, if you've got, as we had here, he would say, two experts each saying that she had capacity, there was no impairment, the judge could not, as a matter of law, make a finding contrary to that, absent any contrary medical evidence. I'm very clear, Mr. Goodfellow was very clear about what his case is, and I understand that.
Yes. I suppose the only thing that that's just playing on my mind is, and it's about what the evidence goes to. And
decision.
Yes.
But it does. The application of this will depend on the actual specific decision. But the principle that the lady's advanced to applies whatever the decision.
Yes.
But it may be more likely that or less likely that a judge would go against the unanimous view of a posse of experts on certain decisions than in others. This decision might be one. It's not impossible.
Yes.
The principle, the lady's principle is applied.
It is. I think it's me that's being slow. I think what's playing on my mind is what we mean by impairment, because it's only if you have an understanding of what you mean by impairment that you can assess whether there is material that goes to that issue. What you have here is material, but it's impairment or disturbance of the functioning of the mind or brain. Mm-hmm. So we are looking at something that is specifically linked to the functioning of the mind or brain. And what you have here is material about the circumstances in which somebody was living and in which their life was sustained, which isn't necessarily material about the functioning of their mind or brain. That's the only. So I think what I'm saying is one needs, in the absence of a diagnosis, in the absence of any opinion or assessment that there is an impairment from any medical person, the judge who's asking themselves the question, do I have sufficient evidence on which I could find as a fact that there is a disturbance or impairment in functioning of the mind or brain, has to know what they mean by impairment or disturbance in order to look at whether there is material on which it is open to them to find that as a fact. And that I know I'm not going to go behind what you asked us not to do yesterday, but this is where there is a difficult borderline between situational vulnerability and impairment or disturbance in the functioning of the mind or brain.
Absolutely. I mean, I think for my own part only, I think arguably a case management decision could have been made that at the same capacity and vulnerability would have been considered at the same hearing to see if either resulted in a decision that a best interest assessment or decision was made. So I, for my part, I'm not blind at all, and not least because the expert evidence makes it clear that the experts regarded her as a vulnerable young adult.
And the experts were specifically instructed to look at both issues, which, as you made the point, doesn't always happen. So I think that's the only point that I'm not disagreeing with you at all about first principles, and I'm not saying more than first principles. But what I'm saying in addition is that you need to understand what it is you're finding as a fact before you can assess whether you've got material upon which you could make the factual finding, which is a very unusual situation because it's bordering on diagnostic. And judges are not trained capacity assessors. And
So what you're saying is that I think the judge's approach, the functional aspects of it will be pretty straightforward. often very difficult decisions to make, but actually it's pretty
You know what you're
straightforward.
doing.
If you then move to impairment, then it's proceed with considerable caution, where there is credible expert evidence, one way or the other.
Milady, yes. In the Skedden argument, we looked at some of the difficulties of looking at impairment in the absence of diagnosis. Agree with what Mr. Justice MacDonald said, that no diagnosis is required. But where you don't have a diagnosis...
So which paragraphs are you talking about?
This, I think, is under the heading impairment in the absence of diagnosis and definition, just above paragraph 57 on page 295.
Thank you.
So in his decision, Mr. Justice MacDonald set out all the disadvantages that there would be if a diagnosis was required as a matter of law, and we agree with all of those. That said, there 295 of the core bundle, paragraph 57. There are some advantages where you do have a diagnosis, because everybody knows what it is they're talking about. You've got a peer-reviewed, codified and described disturbance or impairment in the functioning of the mind or brain. And the judge, without that, is in somewhat what I've called uncharted waters and has to navigate them themselves. And where experts are saying there is no impairment, the judge will be navigating them without the assistance of expert evidence. And I set out some of the disadvantages or the difficulties that there could be. I'm not for one moment saying a judge can't do it, but some of the difficulties that the judge may encounter at paragraph 67 at the bottom of page 297. Subjective elements, and perhaps it's always to some extent a subjective assessment, but one's personal view may come into it. There is a risk of an outcome-driven decision. There is, and I've tried to, I know the Trust takes issue with this at paragraph C, it's really Mr. Ruck Keen's his phrase is pop psychology, which I've tried to expand a little bit in a more neutral sort of way, but there's a danger of using diagnostic type language which is passed into daily lexicon. Something was traumatic, somebody felt depressed, feeling anxious, and using that as elevating it to material that enables you to find as a fact that there is an impairment or disturbance of functioning of the mind or brain. And we may not know what actually the person who's using that language meant by it outside a diagnosis. That's what I meant to D. There's no agreed understanding of what that mental health language means. And there might be normative assumptions about how the individual must be experiencing their situation. It must be playing on your mind to such an extent that your mind is disturbed because your situation is so awful. Whereas the person might say, I've been living with my situation for a long time. I found a way of accommodating it, and my mind is not impaired, neither is it disturbed. I think this is...
There's a real danger of getting into very deep waters because what a 19-year-old might feel could be very different from what an 89-year-old might feel in exactly the same situation.
These are all aspects of the protective imperative. Protection, are they? Or they are mentioned in various cases.
Yes.
It's linked to the subjective. The instinct is to be protective
Yes.
for people who perceive as being vulnerable.
Yes.
And without the solid basis of a diagnosis, there's a danger that may sway the judge or the assessor.
Yes.
And
My lord, yes, I don't want to become too embroiled in the fact of this case, not least because I think that would be unfair to the trust, because the official solicitor's position on this is neutral. But one of the difficulties about relying on perhaps a treating team in a medical treatment is their view that there is an impairment, which I think is possibly what the judge was borrowing from the evidence that Dr. Tunnicliffe gave, is that there might be quite a strong protective element in the thinking of the treating team, because they will have cared for this patient and be wanting, they have a duty to treat that patient in their best interest. They will want to protect them from what they perceive is going to be treatment that is going to be awful for them, such as dialysis or suctioning the trachea, which is known to be painful, and so on and so forth. And it will be a short step to say, I can't exactly put my finger on it, but I think there's an impairment or a disturbance in the functioning of the mind or brain. And it may well be that that is not a conscious thought process, but almost perhaps a subconscious one. I think this is partly what Mr. Justice Cobb was talking about. And I'm just going to try to find a part of my skeleton argument where I've set out a quote from his decision. It's paragraph 54 on page 293. So in the case that I've cited there, Mr. Cobb had a very, very sad case, and is concerned with a young man who died 48 hours after judgment was delivered, and had to make a decision about whether the young man before him had capacity to make decisions about care, including in relation to his passing. And there was clear evidence from an expert psychiatrist about impairment, which the judge accepted, and went on to find that the young man lacked capacity. But he took particular care to think about this because of the fact that this young man's capacity had never previously been in dispute and only came to be doubted towards the end of life. And I draw this to your attention because in this judgment one sees echoes of some of the parents' concerns in this appeal. Over the page, Mr. Justice Cobb says that the question arises about capacity, and it's fair to say that it's only in recent days, or possibly weeks, that question has arisen. And the question has arisen as life hangs ever more delicately in the balance. And then he says it's because the issue has only arisen recently that I need to be particularly vigilant to ensure that those who are looking after RR professionally haven't come to a conclusion about incapacity. And then he gives a list of reasons that one needs to guard against out of expediency, or by applying the wrong criteria, or, and this perhaps feels very poignant in the context of this appeal, because they have been overwhelmed by the palpable tragedy which surrounds the young man and his situation. And that was in a case where there was expert evidence of impairment. in relation to normative thinking and the pressures of end of life, set out in the skeleton a number of different cases concerning people who are at end of life and where their capacity has been in focus. I'm not going to take you through each of those, but the point of doing that was to show that there is no one way of grappling with end of life. Everybody is an individual, and perhaps particularly more than at other times of life, people have a very individual approach. Treating teams must think, might sometimes think, you must want peace, calm, absence of pain. But the case law shows that is not always the case. So it's a short step from we're suggesting a redirection to palliative care, a refusal of that, to then searching for material that could underpin an impairment where there is no diagnosis. Could you excuse me for one moment? I'm going to turn my back very briefly.
Mr. Quintavalli, I see, not unreasonably, that the parents are struggling. Do they want us to just rise for a few minutes?
They want to press on.
They want to press on. Well, if at any stage you feel it's just too much and you want us to rise for 5 or 10 minutes just so you can gather your thoughts and come together a bit, then please tell Mr. Quintavalli and we'll rise straight away. Ms. Pollock should say nothing you've said has been inappropriate or you've been tried to tread a very delicate line. It's much appreciated. I no doubt the parents as well as the court.
My learned friend Mr. Quintavalli said a couple of things about what the official solicitor had and hadn't done at various stages of the proceedings. I'm not going to respond to those. You will know that there's a hinterland and so on, and criticisms are not accepted. We've tried to do the best that we could in the circumstances. Thank you very much.
Thank you very much, Ms. Collins. Yes.
My lady and my lords. Spent quite a lot of time talking about the law and the facts so far. I'd like to first say that although the case which raises some general principles which the court is being asked to clarify, really at base this is an extremely tragic case where an extremely difficult disease with no known treatment has afflicted an extremely intelligent, engaging, I would say delightful young lady with closest family that one can ever imagine existing. And the tragedy that Diksha and her family have gone through, I have no words for. I cannot imagine how difficult it must have been for them. And the way they have fought for her is remarkable, and I mean that sincerely. And I think that's really what we're here to consider, although there are some legal points that arise, but the bravery of Diksha and the closeness of the bond of her parents and brother to Diksha are a great credit to all of them. The question for court is whether the judge was wrong to make a declaration that Diksha lacked capacity to consent to medical treatment, including palliative treatment. That's the order, Court Bundle 43. And as parties agreed at the time would follow that she lacked capacity to litigate. I know you're not going to address litigation capacity separately. That's what the question to the court is. What this appeal is not is, first of all, an argument about whether disagreement with or disbelief in a doctor's opinion without more can lead to a finding of incapacity. Nobody argued that below. The judge didn't find that, and nobody is arguing that proposition now. There are some references in pre-MCA case law to belief requirement. I think they need to be explained, but no one is suggesting that there is an independent requirement for belief separate from the Mental Capacity Act requirements. So no one, as I said, has argued below, or they're arguing now, that there is a specific requirement for belief in a diagnosis, prognosis, or list of treatment options separate from the MCA. Instead, the argument concerns what the second respondent submits are necessary implications of a system which looks fundamentally at whether a person, having identified information relevant to a decision, can properly understand, retain, use or weigh and communicate information which is, as I said, considered relevant to the decision as a matter of law. That information includes, under section 3.4, my Lord Justice Singh pointed out yesterday, includes the consequences of taking or not taking it.
Reasonably foreseeable.
Indeed. And the more serious the consequences, the more significant, as we know from the code, the understanding needs to be. So we can't get away from the concept of, and I'll seek to explain the place of belief in the way that the Mental Capacity Act works. But it's not an irrelevant consideration, acceptance of facts. If a person cannot understand applying statutory criteria or use or weigh relevant information, then they may well not pass the functional test. It's obviously a separate question as to whether the impairment limb is met, and without the impairment limb being met, they still have capacity. Although they are in a no man's land in a way, if they can't make a functional decision, and the court then doesn't have jurisdiction to make decisions on their behalf.
Under the mental capacity.
And the MTA. But then we've got other methods. I don't think Mr. Keane's very happy about those other methods, because they're less principled in the sense that the ambit of the vulnerable, of the inherent jurisdiction is necessarily not one that's well defined. I won't go down that rabbit hole. I've got plenty to say in the time I've got just on this issue, so you forgive me for not addressing that further. But my point is simply that straightforwardly applying the Mental Capacity Act, we've chosen to go down the route not of an outcome-based or a status-based identification of capacity. We have chosen a functional test. That was true under the common law and under the MPA. And under that functional test, what happens is that we model what ordinary people do when taking such decisions. And the relevant information is the kind of considerations that are ordinarily taken into account when that sort of decision is taken. Subject to a practical limit, it doesn't have to be consequences that extend into days and weeks in which ordinary people don't take account of. And that's what the JB case in the Supreme Court, well, my lords, I think were both in the Court of Appeal in it, that was about the legal process of ascertaining what relevant information was. And then you test it by whether someone understands, etc. And that's your functional test. So that's the way the functional test works. And the rest of the test concerns whether there is an impairment or disturbance. And I know we've shortened it to impairment, but it isn't just impairment. It's impairment or disturbance. And you might think this is going to sound rather boring, and I will tell you now, I am going to be like boring in that I'm just going to be asking you to apply the words of the statute. That is going to be my argument about this case. And on impairment, it's an impairment or disturbance of in functioning the mind or brain. And that is an assessment which a decision maker or court must make after consideration of all the evidence. Where it is said that the basis of such impairment is a psychiatric diagnosis, it's certainly easy to see why the opinion of psychiatric experts or treating psychiatrists will be given significant and possibly determinative weight. But at base, it is a question of fact for a judge to ascertain whether the impairment or disturbance in the functioning of the mind or brain. if a person does not accept as true facts about diagnosis, prognosis, or treatment because of, let us say, a religious belief or another belief, that cannot, in principle, ground a finding of incapacity, because it wouldn't arise from an impairment in the functioning of the mind. I know a lot has been said about retaining the freedom for people to live their lives according to their own values. Well, the Mental Capacity Act doesn't attempt to trespass on that. And I'll take you to the textbook extracts that explain it. But just stepping back, there are a number of requirements that need to be met before there's any sense that a religious refusal to even understand or use or weigh particular type of information, to use blood if you need a blood transfusion, if it's because of a religious belief, there's no question that doesn't give rise to incapacity. So although there were some frightening consequences being suggested as a result of fastening on belief as a reason to find incapacity, that isn't actually a real risk when it's properly understood. That's what my submission will be. But I'll show you a number of practical examples where this has arisen. So in this case, the judge found the functional test was met, having considered all of the evidence, including the opinions of Dr. Miners-Wallace, his 2 reports, both stating that Sadiksha didn't meet the functional test, and Dr. Bagchi's 3 reports. And the judge found also that the functional test wasn't satisfied because of an impairment in the functioning of the mind or brain, which she described, and I'll turn to the part of the judgment, it is paragraph 103, I think, and a bit of 104 also, where she provides her reasons, contrary to the opinions of Dr. Bagchi and Dr. Miners-Wallace, but that's his 2nd report that it's contrary to, but consistent with the opinions of Dr. Miners-Wallace's 1st report and that of Dr. Tunnicliffe. And I will show you that in due course.
But can you forgive me for interrupting
No, not at all.
your introductory report?
Yes.
So, just to flag this up when
Yes.
you come to it. Can you simply dissect Dr. Miners-Wallace's 2nd report from his 1st report in that manner?
No. One needs to consider both reports together, and one needs to see what the reason he's given for changing to report 2, whether they stand up to analysis or not. So you can't simply say, well, I'm going to choose the first one because I prefer it. I mean, it is down to a judge what type of evidence, both factual and expert evidence, he prefers. And it's not simply possible to say, well, I prefer the first one. But if there are reasons given, if there are reasons for it, there are reasons suggested why the justification for the change wasn't justified, then a judge is entitled to make that finding and explain it. So no, it's not the easiest thing to do, but it is in principle available. And here, the difference between the 2 was an interview that the reasons he gave for finding impairment were external, objectively verifiable facts. In fact, she'd been in hospital for a year. She'd had various episodes of anxiety. The fact that a study showed, I think, that 46% of patients who'd been in ITU for 24 hours or more had, I think it was depression, if I remember right, and anxiety. And she'd been in for a year. And critically, she had not exhibited any real symptoms of depression. But he was still inferring from that in his 1st report that she was, in fact, suffering from one or both of those conditions. And
well, you're going to be going through all this.
I will, don't worry, this is just an appetite whetter. And then he suddenly flips, rather unexpected, I can say subjectively, to a position that, having had a chat with Sadiksha and her family for 2 hours, the fact that she seemed relatively happy and optimistic in that interview meant that there was suddenly no impairment. And what we submit is that the judge wasn't persuaded by that change of stance, and added to, because the original reasons were still true, that she'd been in hospital for a year, you will often get depression from it. And Dr. Tunnicliffe provided further factual information of the distress, and weighing up all of the evidence, the judge had, first of all, ample material to prefer the hypothesis that there was an impairment on the facts And second, she did explain it, but she didn't explain it in terms of, well, I accept mine as well as 1, not mine as well as 2. But if you look at her findings, she does reject the hypothesis of resilience as being the reason why there is an impairment in paragraph 1 and 3. And that was the essential reasoning from moving from mine as well as 1 to 2. And I am sorry, I was going to save that till the end, but I will. That's our position on the factual basis of impairment and the reasons given. But the point is that both questions are judgments for the court. The functional test and the impairment element. It's established law that there's no question of being bound by expert evidence. It's for the judge to accept or reject expert evidence as long as there's a sufficient basis for the disagreement and that reasons are given, although reasons don't have to be complicated.
When you say it's established law, is that established in this court, in this jurisdiction, or is it first instance?
General, no, well, I'll show the court the jurisprudence on that. There are cases in this court, but there are civil law cases that,
yes,
because there's no reason why the approach to expert evidence in the court of protection would be any different from the general civil law approach. And, though you shouldn't take this the wrong way, your function when you're listening to an appeal where a judge's judgment on expert evidence is criticised is to be very cautious, and there is case law on exactly what your approach should be, where it said that the judge wasn't entitled to reach a particular conclusion on the expert evidence before her. And it approaches an irrationality standard. But I will show you those cases.
Sprintrum and Volpe and Page.
Indeed, well, there's 3 or 4 cases actually that deal with slightly separate points. The other person didn't want me to put all the cases in, but I managed to get my way because one of them deals with appeals against facts, one of them deals with evaluations, inferences from the facts, and another case deals with analysis of expert evidence, and they all look at what the Court of Appeals test should be for interfering in that. And my case will be that we're nowhere near that standard, and that you should not allow the appeal on the facts of impairment. But I hope to make that good. I don't. Certainly am a long way from justifying that at this point. It's clearly a question that the court is concerned with, and rightly so. So we say the judge was entitled to reach both conclusions on functional and impairment on the evidence before her, and she gave lawful reasons for her findings. So I'd like to start, perhaps, and this is a slightly odd way around, but I feel that the court may benefit from going through the chronology, because I'm not sure that anyone has gone through the proceedings briefly from beginning to end, so you have an overview of what happened. And I'm hoping that you've got my chronology that...
Look, source for the goose and source for the gander. I was quite firm with...
No, of course. If it's not going to be helpful, please move me on. I only aim to try and fill in gaps, but if the court doesn't need to see what happened at various...
We'll see how we go, but...
Of course, my lady. No. So, I think it's in the addendum bundle.
Your chronology?
Yeah.
Back of the claw bundle.
No,
Well, that's...
there's a new one that's
A new one.
that's
Well, it's just got
Oh,
page
yes,
numbers.
yes,
It's the same.
I've been working from your new one.
I'm most grateful, lady. I'm sorry, we didn't manage to do paginated one by the time the bundle went in. Can I apologise for the bundles? They're a mess. And it's not good. And I won't go into why they're a mess. Because I shouldn't. But I do apologise for the way the case has been presented to the court. It hasn't at all assisted in me understanding what the issues are, I'm afraid. So, looking at the chronology, Dixie was born on the 25th of February 2004, end-stage renal failure 2021. She was admitted to ITU. So before that, she was studying, and she did, I think, GCSEs and was hoping to do A-levels. And a very intelligent girl, did well, by all accounts. But then, unfortunately, things deteriorated when she was admitted to hospital with pneumonia and COVID and had a respiratory arrest. Stopped breathing 1st of August. There was a failed attempt to extubate, so she was ventilated in between, and she remained in mechanical ventilation since then. And obviously, because of the renal failure, she needed hemodialysis every other day since then. And on the 3rd of October 2022, Professor McFarland, who is, I think, the leading expert on mitochondrial disorders, he leads the NHS group on rare mitochondrial disorders, considered that Sedictia was in a terminal phase. And I'll give the court reference to that. That's Core Bundle 103, paragraph 4.53, which is Dr. Miners Wallace's remarkable summary of all of the evidence. I mean, and I mean that. I think I've literally never seen such a thorough exegesis of all of the evidence in this case, in both reports. There was also a meeting on the 5th of October with Professor McFarland in which Sedictia's aunt, I'm not saying this is directly relevant, doesn't consider that Sedictia had capacity. That's C118, paragraph 6.6. October 22, parents do not consider she's dying. So that's contrary to what Professor McFarland was saying. The LPA was issued on the 20th of November. An opinion was obtained from Dr. Neal. I'm going to show you briefly these opinions, if I may, just to illustrate what the relevant evidence was, who agreed that limitations in treatment were desirable.
Is it necessary for us to go to them?
Well,
I mean, for my part, I've read them all. Every report that's in the bundles I have read.
The only reason for going to it is that I seek to divide it into speciality, and it may help the court to have the mitochondrial evidence, the renal evidence, then you'll understand the course of deterioration slightly better. I don't plan to spend a lot of time on it, but I think just for purposes of explanation, and then there's a whole respiratory angle to Sedictia's health as well, and that would be the intention. But we don't need to spend a lot of time on it, not at all. So 19th of December, a capacity assessment was done. Another one was done on the 20th by Dr. Bagchi. The proceedings were issued on the 22nd of February, challenging the validity of the LPA and to determine Sedictia's capacity, not just litigation capacity, underlying capacity and litigation capacity. And then the statement of Dr. Talbot. And on the 4th of March, Sedictia suffered an asystolic cardiac arrest. And after that point, weaning from the ventilator wasn't attempted. It was thought to be too dangerous. On the 9th of March, there was a hearing for Mr. Justice Francis. And instead of agreeing a capacity assessment, because I think the parents didn't want one, sensitivities were such that an independent ITU consultant would elicit Sedictia's views on treatment, but wouldn't conduct a formal capacity assessment, but may express a view on whether she understood the information. Then a transparency order was made on the 14th of March that now has been discharged. On the 31st of March, a multidisciplinary meeting concluded that Sedictia should move to palliative care with palliative medication to ease symptoms of pain, and that's morphine for pain and midazolam for breathlessness. It's been a serious concern of the treating consultants that when the inevitable deterioration did come, they wanted to know whether Sedictia had capacity to reject these very useful medications that really do work in terms of reducing the extreme distress that one feels during a catastrophic deterioration like that. And that's been a very significant driver for these proceedings, that they couldn't bear the thought that they have this poor young girl in their care suffering hypoxic episodes, but then being unable to provide anything to mitigate the serious distress which she exhibited each time, but she still generally refused palliative medication. On the 1st of April, there was a meeting between the Trust and Sedictia's parents to discuss the care plan, putting in a limit of 60 millimeters of mercury for dialysis. So the problem there was that during dialysis...
I think we know what the problem is. I am conscious that we have read all this, and this is really tough for the parents.
My lady, I am sorry.
We know that, and then they thought 60. No,
systolic, yes. And then they backed down.
And they backed down to 50.
Well, they actually saw how it went, yes. But the point of that...
Sorry, I'm hesitant to interrupt my friend. There's another reason that we are concerned about this, and that this chronology wasn't agreed, because there's simply elements of it which we say are inaccurate. For example, on the 19th of December, there's a reference to Dr. Talbot having conducted a capacity assessment. And if we see the reference, which is on page 193 of the supplemental bundle, it says, paragraph 23, I've not formally assessed ST's capacity, as owing to the anticipated difficulties in establishing ST's capacity, it was determined that an independent assessor was more appropriate. So we are concerned that some of this chronology could be a bit tendentious, and it simply wasn't agreed. And I think, as my lady said about source for the goose and source for the gander, it probably isn't appropriate that we continue with this exercise, given that the court
my lady, I could explain that reference. He did conduct something approaching capacity assessment. It wasn't a formal assessment. And I will explain to the court why we haven't managed to agree on chronology, because there was no engagement with our version of it. I've not had even once any comment from the other side as to which parts of this chronology are not agreed. They simply thought it wasn't relevant. And it's quite hard for the court to know, because one of the points is whether Sudiksha had a rational basis for considering that she hadn't deteriorated. And her kidney function, her systolic, was going down seriously from March, April onwards, to the extent the treating team thought they couldn't carry on with dialysis. And we've got various external opinions to say, yes, it's quite dangerous to go below 60 systolic, remember, and your normal systolic is 120 over 80 of diastolic. If you're systolic, the pressure pushing blood into your arteries is down to that half of what it is normally. You can imagine that oxygen doesn't get to some parts. So there's a very big risk of a cardiac arrest.
That's very clear from the papers.
Well, my lady's clearly read this case extremely thoroughly, and I do apologise for going into these facts briefly. But the point is that it is being maintained before this court that Sudiksha had a rational basis for doubting the doctor's prognostication.
I'm not sure if it is, actually. I'm not sure it...
Well, I think he's actually disputing the prognosis information. He said we never accepted the prognosis cited by the doctors, and it was actually unfair. It's one of his grounds of appeal. Unfair that the judge relied on medical evidence which we weren't prepared to contradict, although we disputed it, he says. That is one of his...
But that's didn't have an opportunity.
Yeah, exactly.
Exactly.
Yeah, that's a fair process argument.
Yeah.
For my part, Mrs. Lechdeva, it's perfectly possible for this court to adjudicate on whether that's a good argument or a bad argument without having to go to the underlying medical material.
Well, I won't labour it. I'll just, if I may, just go through what happened till the end, unless...
Well, that's going through it then, because
well,
the end's
no.
the end.
Well, I'm not going to go to the reports, lady.
No, I really don't think we're going to be assisted by going to the reports.
Well, no, then I won't. The only other points I wanted to make were that so the first of April was about the blood pressure during dialysis. Obviously, we carried on with it. And then I think I've set out the other reports. The 11th of April report, I don't know if the court has seen it. It's at core bundle page 188.
But if it's there, we've read it.
What is the proposition you're seeking to put forward, supported by going through this material?
Well, part of it is the contention that there was no opportunity for the parents to put in evidence to controvert the evidence that was before Justice Roberts. The truth is, they were involved in proceedings all along. They had legal representation at various hearings, and they never made any application to file any.
I identified with Mr. Quintavalli. It was just the fact that Professor McFarlane's report had been filed on the 11th of April, which was 12 weeks before.
But they knew about it in October. You said a similar thing in October 22 about reaching a terminal phase.
So your point is that an analysis of the history would demonstrate there was sufficient opportunity for the parents to seek to obtain alternative other evidence to counter the evidence on which the trust relied.
Yeah. And the other reason for going through the chronology is the reason why there were two experts and not one, and why we had the odd situation. So there aren't many reasons. There are a few reasons I'd like to explain. So Dr. Bagchi was, well, before that we have 12th of April, the trust application for permission to perform a capacity assessment. So one wasn't permitted by Mr. Justice Roberts by consent between the parties, but we decided we needed one given the deterioration. And Mrs. Justice Roberts had to decide. It was opposed by the parents, and she gave a judgment on that at Supplementary Bundle 61. And then on the 14th of April, Dr. Bagchi seized the dicture. On the 18th of April, having first refused to provide a report, he then did provide a report, but in that report he was unable to explain to her or elicit from her, discuss the end of life issue with her. And that was
we know about Dr. Bagchi two things. One, if he knew about the Mental Capacity Act, he certainly didn't apply it.
Yes.
And secondly, that his assessment was conducted not only not against the backdrop of the Mental Capacity Act, but in circumstances where he felt unable to explain very relevant information.
Those are the 2 points, lady. I can move on. You've got them. But I just heard quite a lot about two experts, two cogent experts, how which you differ from.
Well, I think I made it very clear to Mr. Quinterval yesterday.
Yes.
My concerns about
I'll move on.
May have been Mrs. Justice Roberts' legitimate concerns about Dr. Bagchi.
But I think she did make reference to a robust challenge based on insightful questions. So I think she's trying to say that she didn't think much of Dr. Bagchi because he didn't do the job that he was asked to do. And that's why we had the odd situation where the trust, he's the liaison site, so he was instructed on our behalf initially. We made an application to instruct an independent site, and Mr. Justice Francis granted permission for that by an email on the 20th of April, and that's how Dr. Miners Wallace got involved. And then, ironically, Dr. Bagchi was then used by the parents for the final hearing. So he moved from treating, in the sense of having responsibility to look after being the liaison psychiatrist at the hospital. He wasn't, technically, I don't think, an expert, although we may have applied for that, but he was a treating, in theory, consultant. And then he became an expert for the other side. But no one obviously took any objection to that. And then we have the first report, 26 April, from Dr. Miners Wallace, and I've set out other reports. And they all speak with one voice in terms of the renal function being, she's in renal failure from end stage from 2021. So the dialysis is necessary. The dialysis is becoming either impossible or very difficult with the reduction of blood pressure. So two systems are colliding. And on top of that, as we'll see, there are problems with the respiratory system because this disease stops cells from breathing. It reduces the energy supply to each cell. That's why it affects all systems, particularly those that require a lot of energy. And breathing is one of those systems. So then on the 15th of May, Mrs. Justice Judd, the parties agreed what was in effect a palliative care plan in the event of deterioration. And listed a review hearing for the 13th of November. So at that point, the parties had apparently agreed on what should happen. There was then an application on the 16th of June by the parents for an urgent hearing to consider Siddiqia's treatment, and an order of Mr. Justice Hayden on the 30th of June, recording again various agreements in relation to treatment. But then on the 14th and 18th of July, there were two potentially catastrophic respiratory deterioration with hypoxia. I think at one point saturations went down to, I think, 50% first occasion, and obviously if that goes on for any period of time at all, then it can be irreversible. And it's these types of episodes of real distress that gave the reason for the application, and they were anticipated by the trust, and also provides some of the material for the experience that Siddiqia has had, having been in ITU for a year, which is one of the bases for the impairment Then on the 20th of July, the Trust, after these deteriorations, makes an emergency application for the approval of a palliative care plan, the point having been thought to be reached by the Trust that palliative care should be put in. And can I just say that it was always envisaged, certainly by the Trust, that there would have to be a finding on capacity. There was only an interim declaration on capacity. Yesterday, Mr. Pinchvarlo said that, but for their intervention, capacity might not have been litigated at all. Well, how could we ask the court for a declaration on best interest without final hearing on capacity?
What was the basis then for the order on the Justice Judgment? You say that there was a palliative plan agreed with a review in
Well, it was an interim palliative care plan. It was agreed pending the review hearing on 13th of November. There was no final, so there was an interim declaration made by Mrs. Justice.
Is it agreed that there was going to be a hearing on the 13th of November?
That wasn't necessarily, so capacity had been parked by the parties, because there was no need to determine it, given the existence of the order of 15th of May. No party wished to litigate capacity at that point. No party was requiring the court. They were content to proceed on the basis of the interim declaration of capacity.
So, parallel to what was going on before the collapse in July,
Yes.
the plan was, you used the word, capacity has been parked.
Well, it had been parked until the 16th of June, when the parents made an application questioning treatment, and then it was going to be likely that capacity would have to be litigated. So that they result in effect from that agreement on the 16th of June by making it up.
But for that period, between the May and June hearing, the focus was on best interest.
Yes, well, it was agreed. It was agreed what would be given and what wouldn't be given. And they were legally represented, the parents, at that hearing. Of course, no criticism is made. One can change one's mind, but I think the procedural history is of some relevance. So there is then the application on the 20th of July, and then a directions hearing on the 26th of July.
Do we need to go through all the directions hearings?
I think you've got the rest.
Oh, really?
Thank you, lady. Right. So that's the chronology. Now, just for your note, the evidence on the mitochondrial disorder. The evidence is all from Professor McFarland. October 22, I've shown you, I think, referencing the chronology, that's extracted in the Neil report at Core Bundle 243, and also in the supplemental bundle at 192. Basically saying it's likely she's now dying, not immediately, but dying. We should be talking about end of life, and there are no effective treatments for it. That's October 22, and he says a similar thing in April 23, 11th of April 23, and you've seen the note on that, Core Bundle 1889. Now, in relation to renal function, Dr. Berry, 5th of April 23, that's supplemental bundle 200 to 201, talking about the systolic going below 60, risking hypotensive cardiac arrest and stroke. Then we got an external opinion from Dr. Lambie, 8th of April 23, blood pressure drop already occurring is not safe, that's supplemental bundle 249 to 50. Dr. Lambie, 23 April 23, supplemental bundle 286, that when there's a more severe blood pressure drop, the risk of severe adverse events are likely to rise. And then Dr. Pankhurst, 18 July, supplemental 303, condition now worsening as expected. Dialysis will become impossible with increased pressure, so there's further deterioration. So that's the renal function stuff. There is plentiful ITU and respiratory evidence that is, again, of one voice, that there is a progressive deterioration from Dr. Neil, 12 December 22, supplemental 240. Tunnicliffe, I think, 5 statements. Dr. Brown, external opinion, anaesthesia, 11th of April, supplemental 266. Professor Hart, external opinion, 18 July 23, core bundle 191. And then Dr. Rockhead describing the 2 episodes on the 14th and 18th July, core bundle 193 to 195. The tracheostomy and bronchoscopy points are dealt with. My lady, I don't know if I need to trouble.
Please don't.
Right. So my submission there is that rather than Sedictia's predictions of being very ill and dying being inaccurate, there has been a progressive deterioration in her function, renal, respiratory, and generally mitochondrial. And the treating team has gone beyond what they would normally do to keep someone alive, which explains, because they carried on with dialysis below a level that they were initially comfortable to give, which is why Sedictia lived significantly longer than was predicted. In April, it was thought that dialysis would have to stop because it was no longer wasn't safe in the human consultants. Right, can I now turn to the evidence on capacity? I won't go to the Dr. Talbot report, but give you the reference. It's at supplemental bundle 1934. Then we have the first Bagchi report, which is called, but lady, I don't know if it helps to look at Dr. Bagchi's stuff or you're already content with our criticisms of Bagchi. I'll just give you the references if I may then. I'm most grateful, that will save some time. So Bagchi 1 is at C79, 82.
Could I just say about Dr. Talbot report? Did that feature in the Jones?
No, it wasn't really.
Because
it was historic.
For my part, having reminded myself, I think there is some force in Mr. Quintavine's objection to your summary.
Well, it wasn't
we need to go
material.
there. It's not material, then we need
No,
to.
it's just
I just thought I should make that point, having now read what was to.
It's interesting, or possibly not very interesting background.
It is interesting background, but it's.
Could you just remind me of the reference? You said it rather quickly.
For Dr. Talbot,
Yep.
yes, that is supplemental 1934.
Thank you.
He says he hasn't formally assessed capacity.
Yep.
It might have featured more prominently if there'd been a vulnerable issue.
Yes,
It didn't.
we thought it was vulnerable. So Bagchi 1 is at 79 to 82. The OS note, which was taken at the same time, needs to be read at the same time.
Which is in a completely different part of the bundle.
I can only, it is a mess.
It's all right, I found
I'm not
it.
going to pretend this is a good situation. It must have made it very difficult to work out what's going on.
We got there in the end.
Well, there's no excuse for it. But I think when there are procedural disagreements, as we've had in the JV case in the Supreme Court, it's obviously not very attractive to have to come to court to rule on what can go in bundles. So, but then this happens. So the OS note is at C128 to 132.
Sorry, C.
128 to 132, and it's extremely. OS notes are always very interesting. They're always appreciated. In this case, I can, from the trust point of view, it was absolutely critical in the finding of functional incapacity. I mean, we talk about the expert evidence being fascinating. Just the note itself tells one everything one needs to know about functional tests in my submission, because Sedictia denies muscle weakness when told she couldn't do what she was used to be able to. So she doesn't trust doctors in general, doesn't believe she's going to die, denied her blood pressure was low during dialysis, denied she was getting weaker. When told her illness is progressing, said she's not ill, and again says she doesn't trust the doctors, so not just some of them. So that was the context of Dr. Bagchi.
She gave a list, didn't she, of those that she didn't trust, and
Well, later
later
there was a list, but in that interview, it was, she doesn't trust them at all. And I'm not sure that anyone who's given evidence in this case is anyone she has trusted. I'm still not totally sure who the ones she trusts are. Or trusted. But, I mean, people are entitled to decide who they trust and who they don't. My simple point is that even in the OS note, it was apparent what her views in relation to her prognosis and whether she trusted any of the information she was given was. So, then the trust application for a further expert is at S216, and that's useful because it gives the reasons why we were unhappy with Dr. Bagchi.
216.
216, supplemental 216. Then Bagchi 2 is at C83 to 85. That's a note on the 11th of May in which he doesn't say much. And then the third report, which is important, is at C86 to 9. He then gave oral evidence as well. And he agreed in that oral evidence, actually, that there wasn't a social reason for Sidiksha to not accept the medical prognosis she was up. That was the reason that Dr. Miners-Wallace had given for changing from impairment to no impairment. But Dr. Bagchi didn't accept that there was a social reason, and the judge also didn't accept that there was a good social reason for her believing her parents over the doctors.
That's Bagchi 2.
That is
That's all.
Bagchi 3. Oh, sorry, no, that's Miners-Wallace 2.
Miners-Wallace 2, sorry.
So I cross-examined Dr. Bagchi on Dr. Miners-Wallace's reason for moving from impairment to no impairment. And Dr. Bagchi didn't agree that there was a social reason. I don't know if it will assist to have the reference for the transcript of that.
Yes, if you've got it.
It's a supplemental one, isn't it?
It is.
So can I send that to you? I
Of
don't want
course.
to waste time.
So Junior might be able to find it.
Yeah, well, I have marked it. I haven't managed to write it down. So if I can then turn to Miners-Wallace 1, which is at C90,
Would you like us to turn that up?
if that's possible for me.
Of course.
After a quite remarkably thorough analysis of everything, at 143, I think, we reach his conclusions. And at 146, if I can start, I'm going to divide this into functional and impairment. So he does the functional test at 146. 13, just generally on that page. She doesn't accept she's in the final stages, etc., etc. This lack of understanding is a natural protective function, also because of the family haven't allowed him to explain it. And as she doesn't understand her condition, unable to weigh up the consequences, she doesn't trust the doctors, unable to weigh up the information provided to her. So that's just applying the statute. I'm not talking about belief here. Saying, because she won't accept any of the information that's relevant to the decision.
You're reading from 13.6.
13.6.
Yeah.
The word believe does appear, but
Yeah.
but it's well, I'll deal with that, my lord. My lord is right to say that the word belief is used, but my case on belief is simply going to be whether you believe a piece of information or not isn't determinative of capacity at all. You've got to look at whether that then impinges on whether someone understands or can use or weigh information and what the significance of that piece of information is. And if it's a central point, there's a case I'm going to show you in which a lady didn't believe she was pregnant. She was pregnant, but she didn't believe it. And that was effective on the facts of that case. She deprived her of capacity to consent to, I think it was a cesarean section. So there are facts that are central enough that are capable of depriving one of the ability to use or weigh information, but it certainly isn't the situation of you don't believe that, therefore you lack capacity. It requires much more analysis than that.
Well, that may be right, and I don't want to take you out of turn, but when you get to that, the argument about law,
Yes.
the really important issue of legal principle, which this appeal raises, on the face of it, the doctor here says that the fact that ST does not believe what they say means that she is unable to weigh information. And even, and I don't want to parse what the doctor is saying, that's not going to help anyone. But when we turn in due course, when we turn to the judge's judgment at paragraph 93,
Yes.
as I read it, she gives herself a self-direction of law. That belief is something, if you don't believe, you cannot understand.
But that's not quite the way we...
All right, that's fine.
No, we wouldn't defend precisely that
I see, all right.
way of putting it.
All right, well, that's helpful to know in advance.
Because
Yes.
it will be useful to know just how far apart now that
We're not far apart at all.
Yeah, well, I was rather feeling
I'll tell
that
you
you were
where we
creeping
are.
in that direction.
Let's get to the point.
But just before we leave this page,
Yeah.
you went through it quite quickly, understandably, because we're keen that you move on. But belief and believe appear earlier on this page.
Yes.
They appear, and did you say this? You may not have said it. Or you may have said it, and I was falling behind. But at the top of page 146, in 3.2, he says FST believes that the doctor's doing anything wrong she does not accept.
Everything wrong, yes.
So that a lack of belief seems to fit into his conclusion she doesn't understand, as well as his conclusion that she doesn't weigh up. I think the capacity to weigh
Our
up.
submission is that the effect of this evidence is that Fiducia is unable to weigh up the information that he's identified at 13.2.
But
He's expressed himself.
he also says she doesn't understand.
Yes, well, it could impinge on both of those criteria.
Well, it clearly does impinge, because he used the word believe.
Yes.
The fact that she doesn't believe or accept the list of things 1 to 4 in 13.2 is an aspect of his conclusion that she doesn't understand.
Indeed.
His conclusion that she doesn't have the capacity to weigh is partly because she doesn't understand,
Yes.
13.6 first sentence, but also because she doesn't trust the doctor and doesn't
Exactly.
believe.
Exactly. And it's part of understanding because a mitochondrial disease is cellular, it's a defect in mitochondria respire on behalf of your cells. There's a genetic defect in respiration and it gets worse as cells die as you live on, and that's why it progressively deteriorates. And there are very few cases, but the prognoses are generally very poor. So that is, if you simply don't accept that, then in a real sense you're not understanding the science behind contention that this is what you've got. So it is a lack of, if you don't believe anything doctors say, then that is capable, we say, of rendering you unable to understand something.
Is capable.
Yes. But there are no absolutes.
Okay.
I think if you don't believe certain aspects of your diagnosis, prognosis, or treatment, there's no necessary effect on your capacity. It requires an assessment applying the criteria of the Mental Capacity Act, which emphasises an inability to understand and an inability to use a way. And
That's why you wanted us to look at paragraph, whatever it was.
38. As usual, Mr. Justice MacDonald says it better than the rest of us, because that is exactly the distinction. It's and my Lord Justice Singh also made this argument earlier today, that there's nothing objectionable to putting no weight on a consideration, but you have to be able to consider a piece of information and then reach a decision that I'm not going to put weight on it. And that's fine. That's why you can make an irrational decision to refuse, irrational inverted commas, decision to refuse any treatment, and there's no problem with capacity. But if you are in truth unable to understand or use or weigh the information, then that gives rise to concerns, depending on the centrality of the piece of information.
I'm present.
That's the problem with general
Yeah,
statements
yeah,
about if I disbelieve X, then Y, because you might have 5 pieces of relevant information, and you might disbelieve one of them, and it might not be that central, because in 2013 cases at LBL, Mrs. Justice McCurr said that you don't have to understand every aspect.
Salient features.
Exactly, and that's why it must be wrong, though it pains me to criticise a jurist as eminent as Mrs. Justice Manby, but it can't be right simply to say that if you disbelieve relevant information, that's it. You can't understand
If
it.
that's what he said.
Well, I don't think that's quite what he meant. And I'll seek to explain it in its context. Because I must admit that I was in that case, but I don't recall there being any argument at all about this, because quite a lot appeared in that judgment that hadn't been argued about.
That was not necessarily an unusual state of
No, not that anyone was going to be writing a textbook, but sometimes, old habits. But anyway, they're very interesting textbooks on any view, much better than I could have written. But the point is, and on and I'll show you that, belief was part of the ratio, paragraphs 26 and 57, on the facts of that case.
Not over.
Not it.
I thought, forgive me if I've misunderstood, but I thought, having read your skeleton argument, that you were advancing a general legal principle. I mean, I look, for example, at paragraph 3, subparagraph A.
Which paragraph, my lord, sorry?
Paragraph 3A, where you have very helpfully summarised the second respondent's position before this court.
I would add the words, actually, to
Is this in
that.
the skeleton? Sorry, is this in the skeleton argument?
Yes.
Page
254.
Page
Can I-
254.
Can I refine that statement? Or
Give me a moment, I'm not there yet.
Yes.
Now, if you're going to refine it, I need
Going
to
to
hang
seek
on
to
to
refine
every
it.
word.
whether
Right.
Retract.
no, never do that.
Right.
Well,
Refined.
in fact, actually, we only admire an advocate when they feel able
No,
to do
I
that
think
if things have moved on.
clarity. No, things haven't really moved on, but some additional clarity may be useful.
No, please don't.
So where there's objective verifiable medical consensus as to the central consequences, I'm adding the word central. Yeah. Of having or not having treatment, it is
Person must believe.
often the case that a person must believe.
It's often.
Yeah. It may not. Expression
Not
of
we
fact.
change. Not we just delete must and replace
You
it
can
with
do.
may.
Well, you're the judges. You do
No,
what you
no,
want.
what
We
your
want to know how
submission
you
is.
put your case now.
It's may. What
May.
you're saying is may.
May. We all are saying kind of the same thing. Disappointingly, we're all saying the same thing. That lack of belief, or maybe pleasingly, lack of belief in relevant information may give rise to a party failing the functional test.
That is a. Never mind.
That's our position.
It's more than a refinement.
That is our position.
It's an adjustment of your position, more than a refinement.
That's very helpful, if I may say so. And no doubt you will develop that submission in due course. But I have to say, speaking for myself only, that is not what Mr. Justice Mumby said in MM. It is not what appears to have become received wisdom in this area of law.
It's not
And,
quite.
and unless you invite this court to say otherwise, I think this court is going to have to say that that statement was wrong.
Well, I think, my lord, I'm not disagreeing with you. I think there's a way of understanding it that makes sense.
Right.
It turns on the meaning of the word requirement
Yeah.
in Mr. Justice.
That's fine, and sometimes it's
We all say it's may.
well.
That's the-
Well, that's not how I had read the case law to date, right?
Well,
What I'm really saying is, this is an area where there is a real need for clarity.
I wouldn't disagree, my lord.
Yeah, and so fudging things is not going to be helpful.
No, so being serious, it is may, not must.
So can you just encapsulate at dictation's pace precisely how you now put it?
Okay, where there is objectively verifiable medical consensus as to the
Wait
consequence.
a minute, I said dictation pace. Verifiable.
Oh, you added the word
Don't
central.
need central there.
Don't need central. if
No.
you've got may.
Not in the new
Sorry. Where there is objectively
verifiable medical consensus as to the consequences of having or not having treatment. if a person does not believe or accept as true that information, it may be that they are, one, unable to understand it, and two, unable to use or weigh it, for the purposes of Mental Capacity Act.
That's really helpful, thank you.
So that's our position that is not going to change.
But that's not materially different from the proposition which was Philip agreed to when I was
Same thing.
talking yesterday.
Yep. And
But it is different from what Mr. Justice said, or at least seems to be. You'll have to come back to persuade us, or seek to argue why it isn't.
to the extent that Mr. Justice Manby differs from that, this is the correct formulation. His formulation should not be followed. So, functional capacity was dealt with at page 146. Impairment was dealt with at 143 and at 147. And 143 is a reference that my lady gave yesterday, I think, when the issue arose. And it emphasises, if the court wouldn't mind reading 11.1 to 11.4 at this point, if you have it.
Of course.
So 11.1, he's saying her visible distress, both when he saw her, because he did try and see her the first time, and Dr. Banksy also, she was distressed with him. He comments on that existence of that distress, and he said, even if I had been able to conduct a full psychiatric assessment, it would have been difficult to evaluate key psychiatric symptoms because she's in ICU being peg-fed. So even though he did interview her later on, there are these limitations on the ability to elicit signs and symptoms of a psychiatric disorder because someone's in ICU. Then he cites the general study of people staying on ICU being extremely stressful, and citing a study, 13,000 survivors of ICU. This is after they've left ICU, they're interviewed, and they have, some of them had only spent 24 hours in ICU, and over half reported significant symptoms of anxiety, depression, or PTSD. And whereas, so that's 24 hours or more. But Sidiksha, I think Dr. Tankers gave evidence that the average stay in ICU was 3 to 5 days. He spent a year in ICU. And the effect on her of that extreme physical interference with one's wholeness, and you only go to ICU if one whole organ system has broken down, has failed, one or more. The stress that places on someone and the likely effect on their mental state is cited by this study. And what he says here is that situated in ST, this is 4 lines from the bottom, is clearly of an extremely lengthy ICU stay, little prospect she'll be discharged. So these are people who've been successfully discharged, they've got better, no prospect of her getting better. She's been in for a year. He says it's highly likely that although she is not expressing symptoms of anxiety and depression, so she wasn't showing any of these symptoms, but he still thought they were very likely to be present. And when he interviewed her, actually succeeds in interviewing her, she was quite optimistic and resilient. But his finding of likely anxiety and depression wasn't based on her exhibiting the symptoms of anxiety and depression. So the fact that he then interviewed her and there weren't symptoms of anxiety and depression, he needs to explain how that justifies, given her 1 year stay in ITU, a change in that finding.
But these observations are all based on a general.
Yes. Well, no.
On his, they're not based on his examination of them, because he didn't examine. They're based on, I mean, I don't mean to dismiss them. They're based on his analysis and experience of what happens to people in that condition.
They are based on a general study, but they're also based on the assumption that she's not expressing symptoms of anxiety and depression. She's making the diagnosis in her, specifically, without an examination, without a successful examination, but without requiring there to be symptoms of anxiety and depression. Actually, you can, sounds odd, doesn't it? In physical medicine, you can't diagnose something if some of the essential parts are absent. But in psych, it appears that you don't have to exhibit it. And that was exactly what he was diagnosing in Sedictia.
And this features in paragraph 103
yes,
of the judge.
Absolutely.
And the judge carefully uses the word likely.
The judge has adopted Miners-Wallace's one view.
At some point, for my part, we're going to have to explain why it was appropriate for the judge to base her decision on that. The assessment which was conducted without at least addressing the fact that he changed his mind on the basis of an examination.
Indeed. So the reasons could have been better expressed, but it is clear, given submissions made to her and the closings, the trust submission was precisely that you should ignore Miners-Wallace 2 on impairment because his explanation wasn't convincing for, I think, 9 reasons I gave. And that's what the judge did. But without expressly saying, I'm departing from Miners-Wallace 2, I'm adopting Miners-Wallace 1, but that is what she's in fact done. And we say that although the reasons could have been better, they are adequate.
You're going to fall back on Volpe's page.
Yeah, they're adequate reasons in law. It's far from irrational, its judgment, that she preferred the analysis of impairment in Miners-Wallace 1, which was backed up by what Dr. Tunnicliffe had said about her experience, but wasn't simply based on Tunnicliffe.
Yeah, you'll have to work on that because
I'm aware
it is quite challenging to say that when someone has not seen someone and they're not exhibiting certain symptoms, we've got to all work on the basis they've got them anyway. But then when they do see them, they say, right, now having examined this person, this is my view.
So it's not
for the judge then to disregard or the analysis, having seen the patient without explaining that, is a bit of a challenge.
I don't underestimate that, maybe, but at the end of the day, there were 2 theories as to whether there was impairment or not. There was a theory espoused later on that because of the resilience and the wonderful relationship, I mean, what it does show is what literally everyone agrees, what a wonderful relationship Sedictia has with her parents. And that runs through all of the reports. But whether that is plausible up against what actually has been happening to Sedictia on a daily basis, and I will show the court a number of other cases where similar points have been made and findings of impairment have been made based on facts rather than on strict psychiatric opinion. That's exactly what a judge should be doing in finding the facts on impairment. And it's certainly the case that had there been more time, and it was an urgent case, and you saw it was in the vacation, and you could see that the judge couldn't start working the judgment the next day because she was fully listed, I think, for the rest of the week. Well, I had some recollection of that. And my lady and my lords will know what the August vacation is like.
Nightmare.
So even the fact she managed to come up with a judgment like this, I think it's very easy for people to criticise judgments. And I think that if there are 2 clear hypotheses and the judge has plumped for one of them and given the reason that notwithstanding her resilience, she still found that there was an impairment, I think that is adequate reasoning for finding of an impairment. And this court can only interfere on basis in cases which approaches irrationality. And as I say, my submission will be we're not, the facts in this case don't come close to irrationality. There was a basis for her finding. There's nothing in the idea, there's no basis, because there is a basis, but the stronger criticism, if there is one, would be the reasoning. Well, is the reasoning such as to not be able to communicate basis of her finding? Well, no, because there were only two candidates. There was no impairment because of her resilience, and then there was an impairment because of what she had to go through on a daily basis for a year.
Well, it's my fault for dragging you away.
No, I'm happy
and
to
you're but
take
my
away.
fault, you're going to have to get, no doubt at the end of your submission, go through.
No, I will briefly at the end, but I've done most of them now. I think you can all see where I'm going to be coming from on the factual points. You've got the legal point about, there are two big points in this case. The legal point is, what's the effect of belief on capacity? Answer, it may impugn capacity. It may affect understanding, and it may affect the ability to use or weight. It may affect the ability to understand and the ability to use or weight. And then the factual appeal is a factual appeal, and doesn't come close to there was a basis, and there was reasoning. It was lawful reasoning, albeit if it had been during term and she'd had the rest of the week to write judgment, no doubt could have written a more fulsome judgment. Pressures of judgments in August, and that isn't to say there isn't an obligation to provide reasons, but that is part of the essential context. How could it not be? So that is 11.1 to 11.3, and then at 11.4, the stress of a current condition would tax anyone, let alone a young adult. And this is where he mentions resilience. It's unlikely that Esty has been able to build up the emotional resilience to enable her to cope with the significant stresses she faces. So he refers to resilience as a sort of separate category that somehow, if she has resilience, then even in the absence of symptoms of anxiety and depression, the likelihood is that she's got anxiety and depression. But I don't know how then you measure emotional resilience in one interview with someone. Because if the concept of emotional resilience is somehow going to be enough to take someone out of, or they can cope with a year in ITU without impairment of mind,
Well,
then there's a lot of work to do that concept of resilience.
of course, and I don't want to again drag you out of the order of your submissions, but this was the crucial point. This is why he changed his mind.
This is why he changed his mind.
And
But 3 of the 4 reasons he gave for changing his mind hadn't changed. The only one that had changed is his judgment on resilience. He gives 4 reasons, I think, to change his mind. The first 3 are bad reasons, because they were always.
we're going to come on to that.
We're going to come on to that.
And
right
also
now.
and also for my part, I need to share how the judge dealt with the change of mind, and why it was sufficient.
Yes.
Why
She dealt with the 2 theories rather than who had said them.
You'll have to show why it was sufficient and
She didn't say
Therefore,
blah blah
false.
said this.
therefore falls within
Yeah.
the category of judgment with which this court should not interfere. That's
But the remedy for
round one.
for a lack of reasons is remittal to the judge for further reasons. That's the remedy for a lack of reasons. As opposed to, if the judge was entitled to reach that conclusion on the evidence, the remedy should be remittal for further reasons. It's quite difficult for this court to put itself in the shoes of the judge, given that there were, in my submission, a judge could either find impairment or not impairment on these facts. There was sufficient evidence to find that there was an impairment. Anyway, let me show you the rest of this report, and then Miners-Wallace too. So that's 11.4. Then it's also dealt with at 147, 13, 11. And so this is his conclusion at 13, 11. 11.1 to 4 is just the factual background, if you like.
page you want?
That's at 147, my lord. And we say all of these 5 reasons remained extant. Stressing the pervasive nature of her physical health problems, the impact this must have on her mind. Because resilience is one thing, but the fact of what has happened to her, her physical health problems, is continuing and indeed worsening. Because actually, by the second interview, or the first proper interview, she'd had these 2 episodes of catastrophic deterioration. At one point, she asked her mother, I won't read it out, but I think the court's aware,
Yes, we
her
do.
expression of distress, which is cogent evidence of first point, and indeed the third point, the distress, although this is distress at being asked to participate in the ongoing evaluation. I mean, it actually well explains why she didn't want to talk about end of life, because of the trauma she had experienced in her life about it.
I don't think we can speculate why she like that.
My lady, you can ignore that submission. My point is simply that first reason is her physical health problems. Secondly, the impact of a prolonged stay in ITU, and it's an exceptionally prolonged stay, extremely unusual. Refusal and great distress when being asked by me to participate in an evaluation of her wishes and feelings. So what I would say is that the expert is saying that she was greatly distressed.
But
When being
this is all very difficult, isn't it? Because as I recollect, and no doubt you'll tell me if I'm getting the wrong.
No.
My recollection's in error, but it wasn't part of her frustration was, you know, I've done all this. I've spoken to Dr. Bargy. Why? I don't want to speak to you. Go away.
Well, she
Leave me
suddenly
alone.
did. She suddenly, well, so that would be speculating as to.
Well, I think it says in the papers at some stage.
Well, no, she had in the past said why. That was the reason she wouldn't speak to him the first time.
Yeah. And well, this is the first report, and you're
Well-
telling us we've got to draw all sorts of inferences from number 3, and you know, frankly,
Well, no,
it could be just being a stroppy teenager who just had enough.
I don't. So I sense my lady has some experience of that situation.
4 times.
Yeah. Right. Well, in a very good position to speak in that case. My lady, I don't seek to go beyond the express words of this.
Yeah, I think that's safe.
All I would say is that there are 5 reasons identifying factors that haven't changed between the first
Well, then,
and
sorry to interrupt you, that takes us on to MW2, which you're coming on to.
We're coming on to that.
Anyway, you say that we should look at 1311 and those
1311
case,
is
and
the
they're the crux
it's
of
the
it.
summary of her, of Dr. Manus Wallace's
Yeah.
conclusions, but also read with 13.1 to 13.4.
Yes.
Can I just ask you about the last of those?
Yes.
Subparagraph 5. Her fixed beliefs. Speaking for myself only, this begins to concern me, because now we're seeing beliefs coming in the impairment test. So what on the face of it might look like a very objective, perhaps a clinical, physiological, psychiatric test, perhaps on analysis it starts to become fuzzier, and isn't there a risk that because the patient is adamant and
Can't be enough on its own.
No,
Because
well,
that's the functional test
I
turning into.
I understand that. But you say that it does feature, does it, in the impairment test? Because this doesn't, to my mind, this doesn't read like something that you can examine
No.
Right? He says it indicates, in my opinion, an inability, flexible decision making. Well, why should a human being be prepared to be flexible when it's their life or
Discuss
death?
anything. And it's an impairment or disturbance in the functioning of the mind or brain. It's not something you can examine. That you have to look at the whole factual scenario, clinical facts and non-clinical facts. And in my respectful submission, I hear what my lord is saying. It can't be seen to be doing too much work. Simple inability to engage, or refusal to engage, can't ordinarily be enough on its own to constitute an impairment. But if the question being asked is there an impairment or a disturbance in the functioning of one's mind, then if somebody refuses to discuss anything with a doctor, that can be some evidence towards there being an impairment in the function. Right. But one, I completely agree that it can't, if that was the only factor, that would be very concerning.
And beliefs?
Well, a belief can may or may not be an indicator of an impairment in the function of the mind or brain.
So you get it in twice. So if you haven't got through it on functional, then you can bring it back in impairment.
Well, it's just an expression of the fact that all the circumstances are relevant and a belief is capable of constituting a reason for an impairment. I'll show you some of the cases, lady, where courts have had to grapple with this before. There are a number of cases where not believing bits of relevant information has resulted in a finding of incapacity. I think there's about 10 or 12 in the bundle. This is not new. This issue isn't at all new. What is new is that this court is the first time dealing with these rather concrete statements about lack of belief leads to X, which hopefully the court can clear away and explain that it's consideration of the facts of the case and the disbelief, the reasons for it in the context of what is being disbelieved and what the information is overall. That may or may not concern it, but this is not a new concept. And why should it be? Because if what you're looking at in terms of can someone understand or use or weigh relevant information, if they can't accept or use or weigh some of the consequences of their decision, then it will follow that in some cases they will lack capacity. The woman who doesn't believe she's pregnant, or somebody who doesn't believe they've got appendicitis when they have got appendicitis, or somebody with a septic leg that they think they're fine. There's another case where someone doesn't believe they're ill at all. So
and you would put not believing you're dying when you are dying into that category.
Absolutely. That's why, although it's good to have the general principle clarified, and we do need it clarifying, these facts are, we say, orthodox. It would be an orthodox application of the Medical Capacity Act when you're looking at capacity to consent to drugs at the end of life, to not believe that you're at the anywhere near the end of life. In fact, you're past the worst of it and you're going to improve. That is the sort of belief that is capable of impugning the ability to understand and the ability to use the word. Minus Wallace 2 is at 151, and I'd like to first turn to 172. In paragraph 12.4, and this is my point about belief expressed by the father.
Sorry, 12.4.
12.4, my lady, at 172.
Thank you.
In 12.7 at 173, 50% benefit. And that's a long way from the objective fact. The truth is there have been no concrete offers from anyone abroad. There was still a funding issue. And there was a trial, I think, in Canada, but it's been paused at the time. So there were actually no promising leads. And there was no suggestion from anyone that the potential prospect of curing or improving the condition was anything approaching 50%, as you can see from the email from Professor McFarlane in April. Then 1213 at page 175.
Well, it's quite interesting to see what she says in the intervening paragraphs too, to get a flavour of the conversation that she was having. And it's not, is it, a absolutely turning her face against everything the doctors are saying. There is an element of consideration. So, for example, paragraph 1211, she talks about morphine.
Yeah.
Paragraph 12.12, she talks about tracheostomy.
But she has her own views as to what they should be doing.
Yes.
She thinks that she's getting infections because of it, but there isn't any clinical evidence, including the second opinion. I think 2 second opinions from elsewhere said no.
But look at the tracheostomy point. I know this is just a small point, but it gives a flavour perhaps of the conversation they were having. I asked her why she knew why the doctors did not want to replace it with a larger tracheostomy. What were the risks? She said, I might die.
Yes. No, there are islands of...
I asked if she wanted to take the risk of dying rather than remaining with the tube as it is. She said, yes, I don't want to keep having infections. So is that
They're just about the tracheostomy. She won't talk about what would happen if she seriously deteriorated.
So that's an island. You say that's an island.
An island of evidence. I mean, this is an assessment on all of the evidence, and this is some evidence that may suggest that she has capacity, but she then won't. If you look at 1219, or if you look at 1213, family say that they don't trust any of the second opinions from the hospital or from doctors that have not visited ST. So there's a rigid rule, unless they're visited, we're going to discount it. And then at 1219...
Well, more likely, not a rigid rule, it'll be discounted. More likely to accept a second opinion, is what the report says.
They said that, but they didn't in fact accept any of them. And my lady has probably luckily stopped me from showing you every single report which I was willing to, but they haven't accepted any one of them, I can tell you, in my submission. And I think we got about 10 second opinions.
No, I've noted them down. As
never had this many in any case before, because it was so important to make sure that the trust was right. 1219.
Or 1216 on the ventilator. Do you think she would ever be able to come off the ventilator? I don't know. That is my wish. I want to die trying.
Well, she said that on that occasion, but on other occasions she's expressed optimism that she could come off it. So this is just what she's saying to doctors and others on that day.
Capacity is being assessed.
Changes at work. She knows capacity is being assessed that day, and she has made the decision to engage with him, knowing presumably there's a final hearing coming up.
What's the impact of that on your submission?
She's unable to use or weigh up information about the end of her life.
But here she is using and weighing it up, isn't she?
Well, I'm
at
not
the point
saying,
where her assessment is being, her capacity is being assessed.
I'm not saying this is an easy case. There is evidence. There is evidence in different directions in this case. But Dr. Minus-Wallace has been very clear in both reports that he thinks she is unable to understand or use or weigh information about the end of life. That's the expert evidence. And we've heard from the other party of units must put a lot of weight on expert evidence.
But this is whereas before we had a young woman who was refusing to see him.
Yes.
And the doctor the expert basing his view on important but general information.
Not general information about her, but without personal interview, not general
information.
He's gone through her notes, and we couldn't go through that. He really has gone through everything.
So here we have an interview in which there's a lot of interaction and a lot of response.
No, but I'm not going to underestimate the fact that a psychiatrist's opinion based on an interview with the patient ordinarily would be of greater weight than an interview with an opinion without an interview. I have no problem in accepting that. But just on the particular facts of these two reports, we submit the judge was in fact right to choose the -1 theory, but even if she wasn't right, she was entitled to it. And that's the question for this court.
You wanted to go to 219, I was holding you back.
Well, it's simply to do with her attribution of who has kept her alive for a year, 1219.
But that feeds into Dr. Miners-Wallace's ultimate conclusion, in a way.
Well, this is part of his conclusion that she doesn't understand the medical reality of the doctors who have kept her.
Well,
I mean, she might have been talking about being kept emotionally alive, but that wasn't the question. The question was about being kept alive, even though she had some complaints, and she denied that. And that links to the fact she doesn't trust anything the doctors say. Then at 177, paragraph 14, this is his analysis of functional capacity, which, if you wouldn't mind reading 177 and 178.
Certainly.
Relevant information at 14.9. Then at 179, paragraph 15, he deals with impairment. This is his new view on impairment. And at 15.1, he's summarising all of 11.1 to 11.4 and 13 to 11. He doesn't include every single point, but that's an overall. He said in his last report. Then at 15.2, his volte face is expressed. And as the court's aware, he's now had the opportunity to interview her. You see what's said. And at 15.4, he identifies something he'd like to change about his assessment in the first report.
there are two elements of it. Resilience.
Yes.
He underestimated two things: her resilience and how the positive stance of her family contributed to her continuing to hope and plan for the future without being overwhelmed by her significant physical health problems.
So the test, that might be read as she's not overwhelmed, I thought she would be, because A, her resilience, and B, family support. That's a reasonable inference from that. But then, is impairment in the functioning of the mind or brain, does it turn on being overwhelmed? Do you need to be overwhelmed that the test? No case that says that's the test. An impairment of the functioning of the mind or brain requires an analysis of the functioning of the mind or brain.
Isn't he in that observation countering a factor which he relied on in his first report?
Well, that was a factor. My lord is absolutely right. That at 11,
So I summarised in 15.1. Or maybe not.
that is right. Let me find.
Let's go back to the first report.
Yeah, I think it's 11 point. Yes, 4. Coping versus being overwhelmed.
Sorry, I'm
It's page 144, my lord. Paragraph 11.4. But it's a further point. That's not his conclusion. He's not at 11.4. Whether she can cope is not the only consideration, because he's got 3 other paragraphs before that. Signs of intermittent distress. This study where more than half of people have psychiatric problems, and what objectively has happened. So his 4th point is unlikely that she's been able to cope, because unlikely she's developed emotional resilience. That's only an element of his first opinion, and yet at 15.4 he says he's underestimated resilience and thinks she hasn't been overwhelmed. And then the 3 reasons that then follow are exactly the same. That those reasons were all in the same, had the same status when he wrote his first report. So no evidence of structural brain damage was the case when he wrote his first report. What one would expect in this type of report is reasons for this rather dramatic volte-face.
You keep calling it dramatic and a volte-face, but what it is he did a first report not having seen the patient. He did a second report having conducted an extensive interview with the patient
And her family.
and her family, and
Changed his mind.
And changed his mind.
But it is dramatic in terms of the outcome of his opinion on faculty. I don't mean dramatic in any other way. Significant, perhaps I can call it, rather than dramatic. But he relied on 4 or 5 or 6 reasons for the impairment in his
But
first
doesn't that
report.
just show that he's that in the second report that actually he's carrying on doing what he's supposed to, is balancing it all together?
He is, but he's not explaining, hasn't explained why the other reasons for finding impairment were not valid, or it's simply this resilience thing was so important that it overwhelms all the other.
Okay, well, we know you're.
Let's look at his conclusion, which is repeated at the last sentence of paragraph 15.1, little 1 on 179, and there's a 143. It is, in my opinion, highly likely that although she's not expressing any symptoms of anxiety and depression, these are likely to be present.
Yes,
That's
what he initially thought.
And then he qualifies that by saying that in 15.6, the notes show that she's been distressed, that often the context of episodes of pain, not pervasive and continuing, and there's been no mental health recommendation.
Well, just on 15.6, that was the case before. The reports were only intermittent, and it wasn't suggested in his first report they were pervasive and continuing. The whole point was he diagnosed anxiety and depression in the absence of ongoing symptoms of anxiety and depression. And the same obtained in August when he saw her. And then at 15.7, well, reliance on Dr. Bagchi's lack of identification of an ongoing mental health problem is a dangerous business. We don't know what he was looking for. And the judge discounted Dr. Bagchi's evidence.
Well, it's not just Dr. Bagchi, because he says that there's no other treatment. Nobody else has recommended a mental health treatment.
Well,
let's stay.
Dr. Bagchi was the liaison psychiatrist. I don't believe there were any other psychiatrists.
No, but she was being seen by consultants and nurses and dedicated nurses in ITU, any
Yes.
one of whom could have made a referral.
And they didn't. But that was also the case at the time of his first report. So he's interviewed, and 15.4 has changed, and he hasn't dealt with why the other reasons he gave for finding impairment in his previous reports are either no longer operative or important, or the significance of her coming across in an interview as optimistic is enough to outweigh that. And that is the reason I say that's important, is because at 11.2, at page 143, even if he'd interviewed her then and ascertained she wasn't showing symptoms of anxiety and depression, the way that report reads, he would have still diagnosed, or he could well have still diagnosed an impairment.
But isn't the reason why it might be said the interview is crucial, and the two factors he said he underestimated
Yes.
are crucially important. Resilience, underestimating resilience, and underestimating the strength and support of the family is expressed in 15.12.
Well, just on the strength and support from the family, that was apparent from the papers that he summarised throughout.
But he said he underestimated how the positive support had contributed to her presentation.
But he says that, but it was all there in his summary of the report, because the parents have been outstandingly supportive on any views.
Anyway, his opinion at 15.12 is based on that.
It is, my lord.
That's crucial, isn't it, that paragraph?
15.12.
That is what he, in summary, says is the explanation.
Yes.
That he maintains his view that she has an unrealistic belief,
Yes.
but he attributes it to not an impairment of mind, but these other
Yes.
factors. Now, if I understood your submission on the first issue correctly, you were saying, and you certainly say this in writing, that the law doesn't need to be too concerned about the functional test and how belief plays a part in the functional test, precisely because a lot of work will be done by the impairment test. And so, for example, just because let's say, I know it may not be this case, but you've postulated a possible case. Suppose the reason why you have the unrealistic belief, in the view of the doctors, is because you profoundly believe that God will save you.
Well, that's a value.
Yeah.
That's a value that people are allowed to have and should be respected.
Exactly. So isn't
That isn't this case.
Well, you say that's not this case, but isn't it very similar in the sense that what he's saying is it continues to be my opinion that she has these completely unrealistic beliefs, but the reason why she has them is not because of an impairment of mind, it's because of these other social factors. And that may or may not be right.
But he hasn't dealt with all his other reasons for finding an impairment of mind. He said, I think it's the family and the resilience she's gained from her relationship with her. But what does he say about the fact that most people in ITU say that they're anxious and or depressed, and she's been in ITU much longer than the rest of them?
You don't find an impairment of mind because someone's anxious and depressed.
An impairment of mind, in the function of mind, can be caused by the interference with the ability to think. Part of it is he's come across a diagnosis in the first report.
I think it's putting it high to say it's a diagnosis, don't you?
My lady,
I may be wrong. Indeed, said
He's expressed an opinion.
is an opinion as to the diagnosis. Yes, that is a. Well, let's look at it, my lady. Lady may be right. Let's look at what he says.
very likely to be present. That didn't read as a diagnosis to me.
It's a suspicion that she's got anxiety, and he's saying, in his opinion, it's highly likely that anxiety and depression are present, even though there are no symptoms.
But does that really matter? So his ultimate conclusion is, even if there are these factors present, as they would, I would expect them to be, because she's been in the ICU for a year. Look, having seen her, I now think what he says in 15 as well, and 13. We've gone to 13.
Well, the short answer to that is it does matter, because there are still two possibilities for the judge to consider: his first hypothesis or his second hypothesis, for which he's given reasons. The question to the judge is this a good reason for changing the hypothesis? The judge did not think it was a good reason.
Is that a convenient debate?
Hello.
Thank you. How are we getting on?
Well, I mean, I'm confident we'll finish this afternoon. I think Quintivale wanted half an hour's reply, so he can have that. So I'll finish by 3:45 at the latest.
Very well. 2:05, please.
Okay, we'll go downstairs. What are we doing?